Welcome to this free immigration help channel. Today is September 29, 2023, and we are getting into the volume 164 of me answering your immigration related questions. As always, before beginning this video, as I mentioned in every video on this channel, I'm going to mention it here. I'm not an immigration attorney. This is not legal advice. All the information provided in these videos on this channel are directly from official government sources like USAS and of course the Department of State with their visa bulletin. So let's start with the very first question coming from Jetin Caps 1. IR5, what are the timelines to get visa interview after being documentarily qualified for Mumbai? So Jetin Caps, thank you very much for your question, really appreciate it. So IR5, it's an immediate relative category, it's parents of US citizen, which really honestly it doesn't matter which IR category it is, because whenever it is an immediate relative category, the immigrant visa is already available once the I-130 is approved. So you're not dealing with the visa backlog whatsoever, you're not dealing with the visa bulletin, which is definitely great news. Now, not so great news is that Mumbai, as far as I can tell from all the comments that I receive on this channel, it's a pretty busy US embassy, so it does take some time for administrative processing for them to schedule your appointment. Okay, so it depends on when you were documentarily qualified. I would say typically in most of the cases, just I would say average in general, is about 6 months after you're documentarily qualified. 6 months to get that interview, to get that the actual interview. Personally, in my own case, it was 9 months, and I was petitioning for my parents, so it was also IR5, and they waited 9 months. And the U.S. embassy where they went, I wouldn't necessarily say, it's definitely not as busy as Mumbai. Let me tell you that for sure. It's not as busy as Mumbai for sure. So I would assume you would wait a little bit longer than that. Here's a few things that you can do. If it's been about 3 months since you were documentarily qualified, I would recommend calling US Embassy in Mumbai and just being polite, being professional, but asking them, letting them know, saying, hey, I'm a parent of a US citizen. I'm in IR5 category. I was documentarily qualified 3 months ago, 4 months ago, whatever it was. I just wanted to see when my interview was scheduled for. The difference between calling, and I'll explain it because I don't think I ever really explained this, the whole idea behind this, is officially US Embassy cannot give you the notice that your interview was scheduled earlier than 30 days before the actual interview. So let's say if your interview was scheduled for December 2023, you are not going to know when it was scheduled for up until November 2023, 30 days before the actual interview date. Sometimes in some rare occasions they schedule it 60 days beforehand. They not schedule, but they announce it. But most of the times it is 30 days, and they do it because you have to do the medical examination within those 30 days. But whenever you're calling the US Embassy, it is unofficial. So if you do get somebody who is, helpful over the phone, who's understanding, and if you're polite, professional, they might make an exception. It's not that hard for them to just, pull up your name, look into their, system and tell you when your interview was scheduled for, because that's an unofficial, basically, announcement. And it's not really an announcement. They're just giving you the requested information. So it doesn't count as an official announcement. So you might be able to get it. If they don't tell you, don't be upset. Just say, okay, that's fine, not a problem. But it's worth a shot. It's worth a shot. And for everyone who's watching this video, if you're looking for your U.S. Embassy contact information, you can just go to usembassy.gov, and then in this situation, we're going to scroll down to India, click on India, and let's see, New Delhi, and there you go, US Consulate General in Mumbai. So I'm assuming that's where you will be going through your interview. It might be in one of these, but again, if you know that that's where your interview is going to be in Mumbai, then there you go. Here's their phone number. Give them a call. Be polite, be professional, explain the situation, and If they tell you, great. If not, like I said, don't be too upset, because a lot of times they don't. They just say, oh, I can't help you with this. You have to wait, which is still fine. Like I said, in most situations it's 6 months. Mumbai, I would say it's a little bit busier and might take a little bit longer than that. I would say, possibly close to a year waiting, possibly, because it's a busier embassy. All right, let's move on to the next question coming from Nana Bafur 4552. My stepmom filed a petition for my father and me. I was 16 years at the time of the petition, but I'm currently 21 years now, and the interview is next month. Will my age affect it since I'm already 21 years? Nana, thank you very much for a great question. So I'm assuming your mother, whenever she was filing the I-130 petition, she was a permanent resident, because that sounds like, judging from the timeline that you are describing, it sounds like it's, you're in F2A category with your father. So with that being said, being F2A category, yes, the CSPA, the Child Status Protection Act, does not apply the same way as, for example, for immediate relative category, where the age is locked in once the I-130 petition is received. In F2A categories, in fact, with any of the family preference categories, 4 family preference categories that we can see on the visa bulletin, the age unfortunately doesn't lock in, but you do get some benefit of the CSPA, and it's the minus the amount of how long the I-130 petition was pending with USCIS. And in F2A, it's average, I would say probably 6 months to a year, depending on when petition was filed, depending on where it was processed, but 6 months to a year easily, you can take off your age. So if you just turned 21, all right, let's say you're like few months into 21, and you have your interview next month, really nothing to worry about. Like I said, usually those I-130 petitions in F2A category, they at least 6 months, you're waiting for USCIS. Not NVC, we're not even talking about the, documentary qualification, nothing. Just the USCIS once the I-130 was submitted. You can subtract that amount of time from your age and go as obviously. So you are definitely falling into that CSPA age category where, yes, you are over 21 now, but you still go as a child under CSPA. All right. Plus, another thing that I wanted to mention here is usually when you do age out, you do get notified from NVC, you do get notified from the US Embassy, and they tell you that, hey, they don't say we're sorry, but they should. But they tell you that, hey, you are now over 21, you are no longer F2A, you are now F2B. Or you're no longer immediate relative category. No, they don't do that because it's immediate relative category. But they do tell you if you age out, and then they're like, now you have to go under the another category and you have a longer wait. So they would have told you if you aged out. So you have two kind of big pluses on your side. So I think you should be good. Shouldn't be any problems. But again, if you want to be on the safer side, there you go. You can do that calculation. You can go back to, well, you were 20, you were 16, so now you're 21, so that was like 5 years ago. So you can go like 5 years back and see how long the I-130 petition was pending with USCIS, and you can take all that time, whether it was 6 months, a year and a half, and subtract that from your current age, and obviously that will most likely make you under 21 and you should be good to go. Okay, great question, Anna. Thank you, appreciate that, and good luck on the interview. I'm gonna post this answer here, and we're gonna move on to the next one from MD Kamruli Islam 5589. Very helpful. I'm glad this was helpful. Thank you for watching. Moving further to user, unfortunately YouTube does not show me names anymore. They show me handles like this, but I really appreciate you being subscribed. Thank you. So the question is, hello, thank you for your help. I have just filed I-589. Okay, so application for asylum and withholding of removal. Can my sister, US citizen, file I-130 for me? Is it allowed? Yes, absolutely. Bad for approving 589? No, absolutely not. Is there any time recommended to wait after I-589? No, absolutely not. So I would definitely recommend your sister file the I-130 as soon as possible. You know, siblings, that's F4 category. So you're gonna be waiting for a very, very long time on that petition. Honestly, most likely by the time that petition even comes to the, fruition, let's just say that, you're already gonna be, you're granted asylum and you're permanent resident and possibly even US citizen, honestly. Because an F4 category, these petitions, they do take a very long time. I think right now, depending on what chargeability area, but for all chargeability area, rest of the world, it's like 16 years people are waiting. So, but with that being said, yes, I would still absolutely 100% recommend filing that I-130 petition. If you have that backup option, use it. And it's not going to affect your I-589. You might get questions regarding the I-130 petition during your I-589 interview. When you go for your asylum interview, they most likely will ask you. Honestly, I will be surprised if they don't ask you about it. Something like, hey, we see that there is a I-130 petition, family reunification petition from your sister, so you have a sister living here, blah, blah, blah. I don't know what they will ask, but something about it, I'm pretty sure they will ask something about it. And yes, just explain the situation, say, hey, yeah, I was, fortunate enough to come here, and because I'm here now, I feel safe, I don't want to, I'm afraid to go back because whatever the situation based on which you're claiming asylum, and say that, yeah, my sister's here, so I really cannot go back because my life is in danger, this and that, and I-130 is if my asylum takes too long, then I have the family reunification from my sister. So you will get the questions about it, but it's not going to negatively affect your interview or the application 589 in general. Okay, so let me post this answer. Oh, by the way, one thing to keep in mind, that if you do decide eventually to just go with your I-589, or maybe you were granted asylum and that's it, now you're going to be going by that immigration path, or if you do decide to go the I-130, maybe I-589, something didn't work out, I don't know, whatever, make sure to withdraw the application, either this one or this one, if you do decide to go just this route or this route. All right, don't let that just do something on its own. That might cause problems. You definitely don't want to have like a random application being reviewed, being processed while you're doing completely something else. You definitely don't want that. Okay, let's move on to the next question from Simi Chatrath 1239. Sir, please tell when we can accept welcome letter, category F4, petition date 13 March 2006, India. Okay, Simi, thank you very much for the question. Let's take a look at the visa bulletin and see what's going on. So you're waiting for a welcome letter, I'm assuming from NVC, all right? And so we're gonna be looking at the graph B, dates for filing. So chargeability area is India, and I think you said F4, category F4, India, February 2006, and you are March 2006. Wow, you're like right now. You are about a month away from getting that NVC welcome letter. You're right there. You really are right there. Just like one more month, and hopefully that NVC portal will be opening up, and you can start your documentary qualification process. But yes, so as of right now, this is for October 2023. People in October with priority date February 2006, they are, their portals are opening up and they can start their documentary qualification process. And you're in March, which is just 13th March, less than a month away from 22nd February 2006. So really anytime now. Please make sure once you do get your NVC portal opened up, please make sure to come back to this channel, and I would really appreciate personally, that goes for everyone. If you do get your interview scheduled, your petition is approved, your whatever kind of movement that is happening on your case, I do really enjoy reading those comments. People saying that, hey, I got documentarily qualified, I got approved, I got my interview scheduled. I really do enjoy it. It's good to hear questions too, of course, because I can, provide answers, and, it's definitely a blessing. But it's really, really nice to read someone saying, that's it, it's scheduled, so it's good. And I'm sure for a lot of other people too, it's good. So they come into this channel and then they see the questions, yes, but they also see that things are, resolving, things are moving along. So yeah, Simi, you're almost there. It's time to start. I would assume you were already preparing for, your documentary qualification process. But if you're not, I would highly recommend, there is a video on this channel, and I would recommend it for everyone who is very close to the start of documentary qualification process, to the NVC portal opening up. There is a video on this channel called Documentarily Qualified, What Does It Mean? And in that video, I am showing the real NVC profile that was already documentarily qualified, and you can see all of the fees, you can see all of the documents, everything that you need to basically provide in order to become documentarily qualified. So you can familiarize yourself even before your NVC portal is open. So I highly recommend checking that video out. Okay, let's move on to the next question. Looks like there's two comments from Mercy Theory 1613. Good day, I filed my application I-751 3 months ago. So 751 is the petition to remove conditions on the residence. So if you're getting conditional residence based on I-130 petition, after a certain amount of time, you have to file I-751 to remove those conditions. So, and I still haven't received a notice of receipt from immigration. Yeah, 3 months is a little long. I filed through my lawyer. He keeps saying we just wait, but my driver's license is now expired. What can I do? I did not receive a notice. Okay, yeah, Mercy. 3 months is a little bit long for because here's the thing. The notice that you're receiving is literally just saying that we received your application. That's it. They're not reviewing the application. They're not doing anything with the application. They're just taking a look. Okay, we received it. All the documents are here. Everything good. We accept it. That's it. Now, from then on, it's pending. That's when they send you the notice of receipt. And that's the notice that you can go and take to, if you need to renew, especially like your driver's license, that's the notice you would need to show them that, well, I have something pending. Honestly, well, 3 months ago, because yeah, 90 days. No, those 3 months is definitely too long. Mercy, it's definitely too long. Usually you get the notice of receipt within like 3-4 weeks. That's normal. Maybe month and a half, but that's already like pushing it. 3 months, it's a little bit too long. So few possible. I'm trying to think what could have happened. It could have, the notice could have been lost. The application itself could have been lost on the way. Or maybe your lawyer is not telling you something, because if the lawyer, here's the thing, if the lawyer is sending, a petition for you, and that goes for everyone who is using an attorney, an immigration attorney, to file their papers. If an attorney is sending your application package, and if this package is sent back to an attorney saying that, hey, there is a mistake, or you didn't fill out this, or this is missing, and an attorney fixes it, hopefully, and then sends it back, that can cause a delay. So maybe there was something missing from the initial application, and it was sent back to an attorney. And obviously, an attorney would not want to admit that they did not provide something and their first application was not accepted. They're not going to tell you. They will just fix it and send it back, and now it's, en route again. That's one of the reasons why I really find it hard to work with an attorney. I did, whenever I was going through my immigration process, I did work with an attorney, and I tried to find the appropriate word. He screwed me over, okay? Let me just say that. And I mean, my example is my personal example, but I have a lot of people, that I know, friends, relatives who used attorneys and who got screwed over big time by immigration, specifically immigration attorney, because of things like this. You see? Because you don't have any control now. You don't have any control because you allowed somebody else to file application on behalf of you. So if the application is sent back, will you get it or will the attorney get it? Which address is in there? Because in my situation, it was attorney's office, and that was a bad mistake. So what I would recommend doing, I would recommend reaching out to an attorney once again, to your attorney, and then, be polite, be professional, always be polite, be professional with everyone. Explain the situation, say, hey, I still did not receive the notice. It's been 3 months. I know for a fact these notices don't take 3 months to arrive. This is just a notice of receipt. I still didn't get it. I really do need it because my driver's license is expired and I don't have a driver's license. I cannot drive. I cannot go to work. I really do need that to get that notice. So if you received it, please check your record, send it to me if it's his address or her address in the application. If it's your address, well, then you would have gotten, if there was a mistake in the application, then you would have gotten the application returned if there was a mistake. If you didn't get the application back, well, then it means that there is something beyond that problem. There is something, well, it's either, check the tracking number to make sure that USCIS received that application. And then if your attorney did everything correctly and USCIS really did receive the application and you really did not get the notice of receipt, then you would have to reach out to USCIS directly, contact them. You can find their contact phone number. This is their official US Citizenship and Immigration Services government website, uscis.gov. You can find that link in the description below, and you can find their phone number here. Contact USCIS. It's a little bit, finicky. It will take some time for you to stay on the phone and trying to figure out what's going on. Let's see, learn, no. Why would I learn anything about the contact center? I don't need anything about the contact center. Let's try to visit USCIS contact center, in-person service, live. You see, it really is not easy to find the phone number. Please call the contact center there you go, contact center. Let me just copy this and post it into my response so that you don't have to search for that number. But again, like I said, before calling USCIS and going through this whole, hey, I've sent the application, and then they, before doing all of that, make sure you figure out whether the application was filed correctly, what was the return address, and whether or not, there were any problems along the way with the application. And that would be talking to your attorney. Okay, let's move on to the next question, comment from Diego Grieco 1892. Hello, thanks for the video. You're very welcome. Thanks for watching. Do you know if being a member of ASAP can help to waive the biometric fee? Diego, I'm not sure what ASAP is. I've heard of that abbreviation before, but I don't think that's that's how you mean it. But here's the thing: whenever it comes to fees being waived and not paying the fees, typically, if you're not required to pay a certain fee for certain individuals, on the fee schedule page, it will tell you right there that fee is not required. All right. Like, for example, I'm not sure if it's right now, if it's the case, but for a long time, and I hope it is the case now because it only makes sense, But let's say if you were in pending asylum status, you could file I-765 application for employment authorization document for free. All right, and it would actually say on the fee schedule in the table, it will say for I-765, this is the price for everyone, this is the price for this group of people, this is the price for this group of people, and for people with pending asylum or granted asylum, zero. All right, so if it does not say that, where I'm going with this is, if it does not say that on the fee schedule that it is for free, then it means no, you can't, you do have to pay for it. And if you do have to pay for it, in order to waive the fee, you have to file a fee waiver. Now, I do have the video on this channel on how to file that fee waiver. It's pretty straightforward. Basically, you are just attaching that fee waiver, little 1 or 2 page application. It's not long at all, and you are including it with the application package that you are sending. And if it is approved, then they waive the fee. So check the fee schedule page. Again, all that information is available on the whatever application you're applying. In this situation, it's application for temporary protected status, I-829. So check the fee schedule for the I-829. And if you are, if your group of people is not mentioned there as someone who can file it for free, then you can definitely submit that fee waiver, and if it is approved, then well, the fee will be waived. Okay, let me post a response here, and we're gonna move on to the next question. Comment from Andenet Mekonen 2210. Hi, I'm from Ethiopia. My priority date is August 15th, 2022, and documentarily qualified September 11th, 2023. IR1. So when I expect interview. Okay, so you're in immediate relative category, so you don't even need to worry about the priority date at all. But since you are documentarily qualified really just like a few weeks ago, usually, like I was saying in the very first response, the very first comment that I was responding to, usually it's about 6 months after you are documentarily qualified, when you are in immediate relative category, to get your interview scheduled. Personally, in my own situation, it was 9 months, and I've seen some people waiting as long as 12 months, so a whole year. But few months down the road, so right now it's September, I would say give it till like January 2024 and call US Embassy and let them know, saying, hey, I'm documentarily qualified, I am in immediate relative category, I wanted to see when the interview was scheduled for, and they might be able to answer your question. But typically it's about 6 months in immediate relative category. All right, let me post a response here, and we're gonna move on to the next one from Junio3253. What if it was my stepfather's daughter who is in Cuba? I would like to petition her and her husband to the United States. Now my stepfather is 80 years old and I'm working and a financial supporter for him. Can I request and support his daughter to come to the United States under this program? If so, do I fill out the I-130 under Part 1? Relationship section, what should I put? Okay, so if I understand it correctly, we are talking about your stepsister. And yes, absolutely. If you are a US citizen, you can definitely petition for your stepsister, as your sibling. She's going to be in the F4 category, and yes, her husband obviously is going to be as a derivative beneficiary on the application. Here's the thing, however, keep in mind that F4 category is one of the longest categories to wait on, and right now for all chargeability areas it's about 16 years. So just keep that in mind. But yes, absolutely, if I understand your comment correctly, and to answer your question, which Part 1 relationship section is going to be sibling, because, well, it's your stepsister. It sounds like from your comment. But if I'm misunderstanding, please let me know in a separate comment, and I'll try to address it in a later video. And for everyone, if you have any follow-up comments, any follow-up questions, make sure to post them as separate comments under any video, doesn't matter which one, just separate comment. Don't respond to my comment within your comment, because YouTube does not send me those notifications. Okay, let's move on to our last question for today from Medluca6854. Hello sir, I have a question. I enter US with immigrant visa and pay green card fee, and after 2 months I travel to my country without green card, so can't back with temporary I-551 on the passport? Thank you. Yes, Medluka, absolutely 100%. So the cool thing about the I-551 stamp is that once you enter the United States for the first time with the I-551, it converts from being an immigrant visa to becoming a temporary permanent resident card. And I know it sounds weird, temporary permanent, but that's what it becomes until you actually get that physical permanent resident card in your mail, which you already paid for, so that's great. But your I-551 is just as much of a legit permanent resident card as the actual physical resident card that you will receive in the mail in like a few weeks probably. So yes, absolutely. With that being said, you can definitely travel in and out United States, no problems at all with your I-551. So thank you for asking that question. Thank you everyone for asking your questions today. Hopefully my answers were helpful. Like I said, if you have any follow-up questions, comments, feel free. You know, I always appreciate, there's never too many questions from anyone, so you know, it's just I really do get a lot of comments, and a lot of comments, you know, they get, you know, unfortunately I don't have enough time to get back to all of them. So if it is a matter of priority and it's very important and you really do need to get the answer, hopefully it's not like an emergency or anything, because if it is emergency, then you probably need to seek like a legal help or something. But if it is pressing matter, and if I did not get to your comment, just make sure to post it again on any other video, just as a separate comment, and you know, hopefully I will be able to get, you know, in my next volume, get to answering that. So thank you very much for watching everyone. Always appreciate your time. God bless, and I'll see you all in the next video.